Okay. I hope everyone on the Zoom can hear us. Great, okay, so hello, everybody. My name is Stephen. I'm the Deputy Director of the Council's Judiciary Committee. I'm happy to be here at the technically second, but really I think the first. Okay. I hope everyone on the Zoom can hear us. Okay, great. Okay, so hello, everybody. My Judiciary Committee. I'm happy to be here at the technically second, but really I think the first. Okay. I hope everyone on the Zoom can hear us. Okay. So hello, everybody.
There is a really weird loop in the audio.
I can't hear.
Heard your first sentence over
Sorry,
and over.
technical difficulties. Wouldn't be the council without technical difficulties.
There is a really weird loop in the audio.
I can't hear.
Heard your first sentence over
Sorry,
and over.
technical difficulties. Wouldn't be the council without technical difficulties. All right, testing 1, 2, 3. You can all hear my voice just one time. Okay, I like to hear myself talk, but not that much. All right, so hello again. Thank you all for being here. The first, I think, kind of official convening of the Extreme Risk Protection Order Implementation Working Group. This working group was created by statute with the goal of doing a few things. Primarily, and let me get off the list because there's a lot. Improving public awareness of IRPOs, improving interagency coordination with regard to IRPOs, facilitating education of mental and behavioral health professionals on IRPOs, advancing district policies and procedures governing IRPOs, and incorporating best practices from other jurisdictions. An IRPO, an Extreme Risk Protection Order, I'm going to let the professionals talk about it shortly, the subject matter experts, but as a lowly lawyer, I can say that it's basically a civil mechanism to get a firearm out of the hands of someone for whom there's a reason to believe may cause harm to himself or others. IRPOs are becoming increasingly important as legal gun ownership increases in the district, and can also be a tool for someone who illegally possesses a firearm, but is still in that kind of category of someone who we know or have reason to believe may cause harm to himself or others. So, given that IRPOs are kind of new, they're only from the last 5 or so years, or what is it? Some 10 or so years. They are also unique. They are kind of complex. Having this working group is really step 1 in figuring out how to best utilize this unique form of gun violence prevention. I'm not going to ask everyone to go around and introduce themselves because I think the meeting would end before we get to the end of the line, but I'll run through really quickly who's on this in the quickest of terms. We've got from the district government, the Deputy Mayor for Public Safety, the Deputy Mayor for Health and Services, the Office of Attorney General, Metropolitan Police Department, the Office of Gun Violence Prevention, the Office of Neighborhood Safety Engagement, the Department of Youth Rehabilitative Services, the Office of the Chief Medical Examiner, the Department of Forensic Science, the Office of Victim Services and Justice Grants, the Criminal Justice Coordinating Committee, and Department of Behavioral Health. From our non-district partner agencies, we've got representatives from the Superior Court and from the U.S. Attorney's Office. We've got a lot of great community organizations, including Everytown, Moms Demand DC, Giffords, the Hopkins, the Johns Hopkins Bloomberg School of Public Health Center for Gun Violence Solutions. I don't know, it's not your whole name, but that's the beginning of it. Brady, DC Appleseed, the Council for Court Excellence, the DC Volunteer Lawyer Project, the DC Coalition Against Domestic Violence, the American Foundation for Suicide Prevention's National Capital Chapter, the DC Behavioral Health Association, and finally we have representatives of each contractor or grantee of the violence interruption organizations under OAGN1's including the Ward 5 Violence Prevention Network, Dramatic Solutions, Progressive Life Center, National Association for the Advancement of Training Citizens, Alliance of Concerned Men, Father Factor, J&J Monitoring, Life Deeds, Together We Rise, Women Heals, and the Intercity Collaborative. Statistically, I'm sure I left someone off this list because it took me like 3 hours to type up, but so I apologize if I didn't mention organization, but let's going forward, if you speak and add to the conversation, please just introduce yourself and state your organization. With that, we're gonna get started. And I will note that this is being recorded as we all saw, streamed live on YouTube. Double or triple echo, in order to comply with the open meetings act. So with that, let's turn to Everytown and the Hopkins. I'll let you guys read your whole title from your organization. Spencer Cantrell, Lisa Geller, Chelsea Parsons, and Ruby Gongali to talk about ERPOs and ERPO best practices. I will share your presentation here.
Lisa on Zoom will take us off.
Hi, everyone. I have the slides up on my end. I don't know if the folks on Zoom will be able to see.
I'm gonna share them to this one, sorry.
Okay, great. Well, while we're doing that, thanks so much for having us. My name is Lisa Geller. I'm the Senior Advisor for Implementation at the Johns Hopkins Center for Gun Violence Solutions. I am also a DC resident, DC native, and a mayoral appointee on the District of Columbia's Domestic Violence Fatality Review Board. So I'm really thrilled to be here and see so many familiar faces and partner organizations in the room. So thank you, Stephen, again, for having us. We'll go to the next slide. Everyone will just introduce themselves before they give their little section. I think most folks here know what extreme risk protection orders are, so we will just gloss over that. I want to talk a little bit about the research behind it. Obviously, at Hopkins, we do a lot of research on gun violence prevention policies in general, extreme risk protection orders in particular, as do a lot of our research partners around the country. We also have some DC ERPO data, although I know Sarah and Tara will give a great overview and deep dive on that as well. And then we'll talk about a report that we jointly wrote, the four of us, that came out in May of 2023, and we'll make sure you'll have a QR code to scan it. I think Spencer probably brought some hard copies. If I know her, she probably did. Someone else did. So you might have some in the room. And that is it for our agenda. We'll keep it to, I think we have 30 minutes, right, Stephen?
Sure, but we're flexible.
Okay.
We're all nice and cozy in this warmers.
All right, next slide, please. All right, so we covered this. Extreme risk protection orders are civil protection orders that are designed for a very specific purpose, and that is to intervene when someone is at risk of suicide and or interpersonal violence, and it gives this clear legal authority to issue a temporary firearm removal and prevent the purchase and obviously possession of subsequent firearms. So as of this month, March 2024, 21 states and DC have extreme risk protection order laws on the books. Most recently, Michigan and Minnesota's laws went into effect this year. But so what we like to say now is that more than half of the country lives in a state or jurisdiction that has an extreme risk protection order. And there's also a growing body of research, as I mentioned, that we've done at Hopkins and others have done around the country, showing that these can be an effective tool to prevent suicides, but also other forms of violence. So mass shootings, we've seen them used in efforts to prevent mass shootings, and other forms of interpersonal violence, including domestic violence, that I'm sure Sarah and Tara will talk about as well. So next slide. This is the map of the jurisdictions, states that have extreme risk protection orders. These were modeled off of domestic violence protection orders by and large. So they're civil in nature. They are designed, again, for a very specific purpose. So when we talk about this as a remedy to preventing violence, particularly when we're talking about domestic violence, we want to make it clear how these are actually based on domestic violence protection orders, but different. They do not offer the protections that you would get under a civil domestic violence protection order, including no contact orders, stay away orders, any type of economic support, et cetera. So if you are working with a victim survivor, of course, being aware that this just removes the firearm that an individual currently has and prevents them from purchasing subsequent firearms while the order is in effect. So very specific, tailored nature, not designed to be used in all cases of violence, and certainly is not going to be our be-all, end-all to solving our gun violence epidemic. Petitioners in the district go beyond just law enforcement. That's good. That's a promising practice that we recommend, that it not just be law enforcement that's able to petition for this tool. So most states have expanded beyond law enforcement as petitioners, most often including family and household members, but some states like DC have added healthcare providers as well. So just like the domestic violence protection order, there's this ex parte or temporary order that is meant to address that real acute risk of harm. And then there's a final order that in most states lasts up to 1 year. Next slide, please. I want to also talk about mental illness as a risk factor or not as a risk factor for gun violence, because when the extremist protection order policy, the modern extremist protection order policy, was being adopted and was being crafted after the Sandy Hook shooting, a lot of the media narrative, a lot of the public discourse was talking about mental health as the reason, or mental illness as the reason for our gun violence epidemic. However, we know that this is not true. We know that people living with mental illness are more likely to be victims of violence than perpetrators. And so when we train folks around the country, and particularly when we're talking to judges who are making these judgment calls and considering all of the relevant evidence, it's very important to us that mental health diagnosis alone not be the impetus for requesting or granting an extremist protection order. That does not mean that there are not certain situations where a mental health diagnosis or a mental health issue comes into play. Of course, I'm not saying that, but diagnosable mental illnesses such as, depression and ADHD, those are very common. 1 in 5 Americans live with a diagnosable mental illness. When we're talking about severe mental illnesses, there's about 1 in 25 Americans. And of course, that's millions and millions of people. It's not going to be the reason why we request an IRPO on their behalf. So mental health diagnosis alone, not sufficient. We're really looking at histories of violence and past violent behavior. So next slide. We do have evidence, we do have some studies that have looked at the impact of extremist protection orders on suicide in particular. A study from Connecticut, and there's a study from Connecticut and Indiana, found that for every 10 to 20 firearm removals, so not every 10 to 20 IRPOs issued, but every 10 to 20 firearm removals, 1 suicide was prevented. So we do have, I would say, the strongest evidence that extremist protection orders can be a suicide prevention tool. And certainly when you look at this chart at the right, which came from an Annals of Internal Medicine article, you can see the case fatality rate for firearms is just so much higher than any other means. So about 90% of suicide attempts with a firearm are fatal. When you look down at other causes, poisoning, gas, hangings, even hangings and drownings are the case fatality rate is a little over 50%, but for the rest of them, it's much lower than that. And so we can't talk about suicide prevention, we can't talk about homicide prevention, certainly without talking about firearms. And that's why putting time and space between someone who's at risk of suicide or homicide, putting time and space between them and their firearm is really shown to be a good practice and life-saving tool. So I'll just skim over that because you'll get an access to these slides as well. So next slide. I think this might be my last slide. A recent study, my colleagues and colleagues around the country are doing a multi-state IRPO study looking at 6 states that have extremist protection orders. You can see they're listed here: California, Colorado, Connecticut, Florida, Maryland, and Washington, looking at IRPO case files from those states to see trends in orders, to see, why they're being used, what the demographics are for respondents and petitioners, and all that great information that makes us better able to show what's going on around the country and then inform our promising practices. What they saw after looking at over 6,500 IRPO case files in those 6 states was that about 10% of those petitions were filed for a response to a threat to shoot at least 3 people. So high fatality shootings, mass shootings, highly lethal shootings. There's a lot of different ways to quantify these shootings. But when they were looking deeper into that data, the most common targets were K through 12 schools, businesses and intimate partners, children, and their families. So threats to shoot up schools, businesses, and family and household members. What they also saw was that judges granted orders overwhelmingly in these cases. And that's not because they didn't have insufficient evidence, they just were granting them willy-nilly. It's because they actually had enough evidence that a judge was comfortable granting this order and saw this as an effective tool to mitigate harm in those particular situations. And we do see this around the country, not just in these 6 states, that judges are being diligent, being thoughtful. We see also very little misuse of extremist protection orders by and large. So that is all good. That is great. That's exactly what we want to see in this data. We want to see ERPOs being used to address very particular instances of either suicide and or interpersonal violence, because we do oftentimes see a threat to self and a threat to others when looking at the case files. And I've read a lot of case files at this point as well. So I think that's it for me. Next slide, I should say. Oh, okay. So I have one more slide, I think. So these are just some reflections that we've seen from around the country looking at extremist protection order implementation. We see great variation among states and within states. So we see that Maryland is implementing their extremist protection order very differently than Washington State is, but we also see when we look at what's happening in Washington State that there's variation between what they're doing in King County, what they're doing in Spokane. I mean, there's lots of variations within counties or within states and between states. We also see that almost all petitioners for extremist protection orders are law enforcement, except in Maryland when we see almost a 50-50 split between law enforcement petitioners and non-law enforcement petitioners, particularly family and household members. Our neighbors in Maryland also are unique in that they've used an extremist protection order in every single county within the state. There's only a couple states where that's true. Like I said, when we look at some of the state implementation data, we might see this really high user county like we see in Fairfax County in Virginia. High user county, they're doing, last I checked, I think about 25% of the orders for the entire state of Virginia. So Maryland's unique in that every single county has used this tool. As I went through, we have mostly descriptive studies to date, but do have some evidence showing that this is a suicide prevention tool. We see ERPOs used in a variety of issues. And what my colleagues will turn to for their part of this presentation is that we have promising practices for implementation. It is typically done at the local level, and we do have some models around the country that potentially could serve as a guidance for DC, although the folks in this room and on Zoom are doing an amazing job in the district. And then the last thing I'll say is that the Bipartisan Safer Communities Act was the bill that was signed into law by President Biden in June of 2022 that actually allocated federal funding to implement crisis intervention orders, including extremist protection orders. So Spencer and I met with the state administrating agency for DC on Friday with Director Porter to talk about potential ways in which DC can use this funding to enhance the efforts, not to duplicate efforts that are already going on in the district. So now I think that's my last slide, although maybe I'm wrong. Yeah, okay, I'm done. And we'll turn it to my 3 colleagues in the room.
Good afternoon, everyone. My name is Ruby Bengali. I work at Epitaph for Gun Safety and the research team of the senior advisor for implementation. I work closely with my colleague Chelsea over here to make sure the gun laws that we work so hard to advocate for across the country are actually implemented on the ground once they are in effect. Thank you so much for the opportunity to be part of this important discussion and to share some of the data that we've been gathering. Next, please. So over the years that DC has had this law, there has been some media attention regarding its limited use and the opportunities for increasing utilization of it. One recent effort made to that end was an expansion of who can petition for an ERPO, which is part of the Omnibus Anti-Crime Bill. And according to the new provisions, the definition of dating partner has been clarified. I'm not a lawyer, so I'm not going to go into the specifics of what that is. And it also expands law enforcement officers who can file from just the DC Metro Police Department to any sworn member of a law enforcement agency operating in the District of Columbia. Next slide. So what does the data tell us about implementation across the country and in DC in particular? To better understand that, my team and I have been gathering data on Urbo petitions and orders from every state that has the law in effect on an annual basis since 2019. And for most states, including BC, we get that data from the courts. As Lisa was mentioning, we see in the data a great variability across the state and within states. But we have been promisingly seeing increases in the usage of Urbos across pretty much every state. Since 1999, which is when the first extremist law went into effect in Connecticut, up until 2020, which is the most recent year of data that we have so far, over 34,000 Urbo petitions have been filed in 19 states and BC. Minnesota and Michigan that Lisa was mentioning are not on the list currently because they just went into effect this year, so their data obviously isn't on there. Now, I know this table is difficult to read. It is publicly available on our website, and I can share that link later, and the slides will be shared later. But for some of you who can see on this, the rate of usage across the state is widely different, ranging from 23.3 petitions per 100,000 residents in Connecticut, which is at the top of that list, to 0 in Hawaii, and everywhere in between. Connecticut, New York, Florida, and Maryland have had high rates and have been on the top of the list pretty much across years. Whereas on the other hand, New Mexico, Nevada, Massachusetts, and Hawaii have been down at the bottom. Washington, D.C. sits roughly in the middle, though their rate is much lower than the states that are at the top. And as I mentioned before, for some of these states, you see their rates pretty consistent across counties, but for most of them, it's pretty widely different within the state as well, where we see a particular county or a couple of counties usually at much higher rates than the rest of the state. Moving on to the next slide. So this is data that we've received year on year from the Superior DC Court. Since the enactment of DC's law in January of 2019, there have been 37 Urbo cases. These have ranged about from 3 in the first year to 17 in 2022. And again, across the years, we see that the vast majority of these cases have been granted temporary and final orders. And most of the times, the court staff that sent us the data notes that when they're being denied, they're most often being denied because the petitioner withdraws the petition. So again, most of these cases are pretty severe enough that judges are ordering these purposes. In 2022, for the first time, we received data on who the petitioners are for the cases, which revealed that 47% of them came from a civilian petitioner, meaning a household member or family member, an intimate partner, and 35% were from the Metropolitan Police Department. About one case was initiated by a mental health practitioner. Now, all of this data comes from the court, so I'm going by that. Which will bring me to my last point as a researcher, is that while this data is extremely helpful, there is need for much more. There's need for filling a lot more gaps and inconsistencies. Year on year, the data that we've gotten hasn't been consistent. They've sort of changed what's been collected or what's been shared, perhaps. And we definitely need more information on each case, such as demographics of respondents and petitioners, firearm surrender, reason for petition, etc. Which would better help us understand how the law is being implemented on the ground. And with that, I'll pass it along to Chelsea to talk about strategies for implementation.
Yeah, thanks, Ruby. Hi, everyone. I'm Chelsea Parsons. I'm the Senior Director for Implementation at Everytown for Gun Safety. So I'm going to talk a little bit about a project that we did in partnership with Hopkins to figure out how to help support jurisdictions effectively implement these laws. And so extremist protection order laws are relatively new. Most of them have been enacted since 2018. And for the most part, these laws have been enacted, and then the legislature congratulates itself and then expects it to magically work and to solve all of the state's problems with gun violence. And so what we set out to do was talk to folks in jurisdictions that have been using Urbo a lot, talk to folks in jurisdictions that have faced some challenges in using it, and really pull together the best current thinking from jurisdictions around the country about the model approaches to implementing these laws. What's working well? What are some of the opportunities that exist to really make sure that this law is able to be put to its best possible use and is equally accessible to every community? So we pulled together a bunch of folks in December of 2022. And that led to the report that we released in May of 23. And so if you go to the next slide, we're going to talk through some of the best practices that we identified through this project, particularly as it's relevant to DC. And again, like Lisa said, the district is actually, you all are doing a really good job. In fact, and a lot of the things that that we talk about and we highlight in the report as best practices are things that are already under the district. So if we go to the next slide, so the first thing that we really focus on is creating the infrastructure to support this process. So an extreme risk protection order is the final result of a long-ish civil court process. And so you need to have an infrastructure in place that really addresses each stage of that process, from before a petition is filed, when perhaps an evaluation is occurring as to whether or not it might be appropriate, through the filing, through the court process, and then through the process to serve that order and eventually surrender of firearms. And so all of those things involve different key partners and stakeholders in the jurisdiction. So it's not enough just to say, okay, we're going to train law enforcement, because you need to have folks aware of and understanding their role in this law at all of those different stages. And so having a strong infrastructure around that law is really crucial. So we're doing it already. We can check it off. Creating a local IRPO working group is something that we've identified as being a really effective practice. Really having people who touch different parts of that process, regularly getting together, talking about the process, identifying barriers and identifying places where perhaps we need to come up with some solutions. A few other things in the infrastructure category, Ruhi mentioned the need for data. This is something that is more relevant in states that have multiple jurisdictions, where you get really inconsistent data across jurisdictions. And so making sure the state as a whole is kind of collecting the same kind of data. Implementing a standardized IRPO training curriculum. This is really important when it comes to law enforcement. So making sure law enforcement is getting consistent and regular training about this law. We know that there are new officers coming in all the time, and so really making sure that it is both part of a new officer's training as well as part of kind of ongoing training that officers get throughout their time on the force. Increasing awareness of IRPO laws through targeted education and outreach efforts. This is something where I think there's a lot of opportunity in DC to really do a robust round of outreach to folks in the community who are most likely to come into contact with individuals or family members who may have need for this tool. I'm thinking in particular about the mental health community as folks who can file petitions themselves, as well as other folks who, again, are serving families or providing different kinds of services and may be in touch with families who are in a situation where perhaps removing the firearm is a really important element of kind of addressing that crisis in a particular moment. And then we also talk about having dedicated IRPO judges, dedicated IRPO leads in law enforcement agencies, really creating the opportunity for those professionals to develop expertise in this kind of case. Lisa was mentioned kind of, talking about the issue of mental health diagnoses as not being a necessary or a sufficient part of an IRPO proceeding. Part of how you ensure that that is how the law works in practice is making sure that the judges and the other professionals who are working on these cases are very well trained and really develop expertise in this area, so that they are familiar with all of those things, and you're not kind of starting from scratch every time you file and you see which judge you happen to get for that case. And we go to the next. So then we talk about the pre-petition inquiry stage. This is kind of the process before a determination is made to file one of these petitions. And so, what we found is having a process for assessing IRPOs alongside other potential crisis intervention tools is really important. So we really like to consider IRPO in the context of the entire range of potential interventions in particular cases. So Lisa talked about domestic violence restraining orders as one, thinking about other kinds of behavioral health interventions, perhaps involuntary mental health evaluation interventions, up to and including, potentially the law enforcement intervention. So we want to think of IRPO not on its own, but as part of an entire spectrum of potential intervention options that may or may not involve a legal action. Again, considering whether an ERPO is appropriate in a criminal case, or either in addition to as an alternative to criminal charges, I think another area where there's a lot of potential opportunity is really thinking about ERPO as a tool of diversion. If you have a situation where the most urgent need is just removing the firearm from a situation, perhaps that can be accomplished through the civil proceeding as opposed to arresting somebody and kind of going down the path of criminal prosecution. And I think that that's a place that there has not been a lot of work to that effect, but I think that that is really part of the intent behind this law, is to be able to use it for that purpose, particularly in DC where, I have on here, having considerations for when a person in crisis possesses a gun unlawfully. DC is really unique among all of the jurisdictions that have this law in that it is written into the statute that there is an amnesty provision for a person who is unlawfully in possession of a firearm. If they have an extremist protection order issued against them and they voluntarily surrender that firearm pursuant to that order, they cannot be prosecuted if they are unlawfully in possession of that firearm. That provision does not exist in other states, which really creates a pretty significant barrier to using this tool in a lot of situations. And so I think, the Attorney General's office does a really good job of educating people about that aspect of the law, but I think that DC really could be a model for using the extremist protection order law and really taking advantage of that amnesty provision to expand the use of this law in communities that perhaps are not traditionally thought of when it comes to using an extremist protection law. We sometimes really hesitate to promote using ERPO where we know that there's a lot of concern around law enforcement involvement and around the potential for charges for individuals who may be unlawfully in possession of a firearm. And so the fact that the law was written this way is really smart in that respect, because it really does open up the potential applicability of this law to a lot of those situations. Another piece here is really thinking about how can we collaborate with service providers to connect ERPO respondents to resources. This is something that's not written into the law, and it's not written into any ERPO law. And ERPO just does one thing. It just impacts a person's ability to legally possess a firearm. It doesn't do anything to address the underlying root causes of whatever the crisis is that has led to the situation where the person poses a risk, but they do have access to a firearm. And so one of the things that we feel can really be accomplished by that working group, by that kind of collaborative effort around the law, is identifying pathways for ERPO respondents to be connected with resources so that we are actually working to address those underlying causes, as opposed to sort of putting a Band-Aid on the situation for a moment by removing the firearm, but not really helping that individual in whatever kind of help they may need in order to get themselves out of that crisis situation. And then the last thing I have here is, creating supports for non-law enforcement petitioners, and I think Spencer will talk about that as well. In most jurisdictions, ERPO petitions tend to be filed most often by law enforcement. I think it's really interesting, actually, that Rudy got the data from DC that you are seeing a lot of family members filing these petitions. To the extent that we can think through how do we continue to support family members and mental health providers if they do seek to commence this process, it's an extremely intimidating process. You have people who are in a really urgent crisis, really concerned about a family member. And so also asking them to go to court on their own, to go in front of a judge on their own, to kind of put all of that out there, I think is really intimidating. And so how can we help support those folks to make sure that the process can work for them and that they can feel confident starting this process without resorting to law enforcement in the first place? Go to the next slide.
You want us to hold questions to Leanne?
You are in charge.
Whatever you'd like.
No, go for it.
So for the amnesty, does that, and I remember the deliberations, but I can't remember where the law ended up. Does it also prevent police from doing a trace on the gun? I don't, even if it's so they could.
It's amnesty from possession or.
So just for that.
Right. So if someone was used in a homicide or something.
Of illegally possessing. I got it. Okay. Thanks.
Okay. So, and then the last thing is, the next stage of the process that we look at when we're looking for best practices is that actual courtroom process and being able to file a petition. So again, making sure that the court forms are really clear and really accessible, making sure that they're accompanied by plain language instructions, that they're available in multiple languages. All of that helps increase the accessibility. And again, making sure that, or trying to ensure that the courts have a process in place that is kind of a 24/7 process, because we know that these kinds of cases really can involve an emergency and a crisis that needs to be addressed as soon as possible. So I'm going to stop there and hand over to Spencer.
Yes. Hi, everyone. Spencer Cantrell. I am also a senior advisor for implementation at the Johns Hopkins Center for Gun Violence Solutions. And so I'm going to just talk through a few of our last recommendations before I think the next folks on the agenda for today are going to talk about like what's really happening in DC. So I'm really excited for you to hear from Sarah and Tara, who we worked with. But just want to keep going over a few more recommendations and echo what Chelsea said, that a lot of this is already being done in DC. But I think in every jurisdiction where we're working, we visit it, there's always room for improving systems, right? There's always room for increased coordination, increased data collection. So just want to highlight a few more best practices. Service of the order and firearm dispossession. I think this is where folks often get really anxious about what's going to happen, right? Because we know when firearms are removed that tempers can really flare. So one of the recommendations we have is to have a protocol for service with highly trained specialized officers, right? And in some jurisdictions, I've seen this being like folks that used to do hostage negotiations are the ones that are going in for firearm removal, because you want it to be, based on what we've seen around the country, you want it to be a conversation. You don't want to just come in with sirens on, SWAT teams. That might be necessary in a few limited instances, right? But you want to come in and figure out how can you de-escalate things, and having specially trained officers to do that is really key. But for every time you're serving an ARPO, you want to have an individualized safety plan. How are those firearms going to be removed? Who's going to be a part of that? And what, to Chelsea's point, what led to the crisis and what might you do to address that, prevent something from happening in the future? You also really want to look at what's going to happen if the individual doesn't comply with ARPO, and how are you going to get that information? So someone surrenders 2 firearms, but you say that they have 3. What's the procedure? What's the protocol? What are the next steps going to be? And standardizing that is really critical. We've seen in some jurisdictions having compliance hearings where the folks come back a week after the final ARPO is ordered, and they state under oath, they sign an affidavit that all the firearms have been surrendered. But if the firearms are surrendered before the final hearing, between the ex parte and the final, then that final hearing can be an opportunity to try to verify compliance. It's also really important that you talk to the petitioners, family members, others who have information about that respondent, who know what weapons they have or have access to, in order to ensure that compliance. Next slide, please. It's also really important to think about, what do you do when the respondent has access to guns that are owned by other individuals? So I've seen that in many instances where children have access to a parent's firearms, but I know I've talked to some folks in DC that there might be shared firearms, right, between different folks. And so what do you do when that person doesn't own it, right? But how do you look at what that access is, and how do you really prohibit access going forward? Something we've seen as a best practice that I think can be a little bit controversial in some cases is looking at multiple firearm storage options. So in some jurisdictions, we see firearms being surrendered to third parties. That's a family member, a firearms dealer. Some folks are really, really trepidatious, right, about dealing with systems, trusting law enforcement to hold their firearms. And so what can you do to balance that while making sure that the firearms really are restricted from being accessed, while making sure that that individual can comply with the order? So I was just talking with someone in Multnomah County, Oregon, who, they say, I'll surrender my guns, but I'm not giving them to the police, right? So what do you do when people have that distrust to make them comply with the orders? And then it's really key to have clear protocols for how do you return the firearms after the order expires. Do law enforcement notify the respondent? Does the respondent need to reach out proactively? And what inquiry is done before the expiration of the order to make sure that it is safe to return those firearms to the individual? So are you talking with the petitioner? Are you talking with other witnesses in the case? What are you doing to verify that it's safe for those firearms to be returned at the expiration of the order? Next slide, please. As to special considerations for non-law enforcement petitioners, I think law enforcement are working on this in a lot of jurisdictions more often than other petitioners. But it can be really overwhelming for mental health professionals, other physicians, family members to know what to do and how to proceed. So having specialized training and outreach for these other professionals to understand what is this, how does it work, what is my role, how does it work if I'm an on-call doctor in the ER and I want to file an IRPO, who's going to cover my shift, when am I going to be on the docket, is there an attorney present, what do I have to say, right? There's a lot of concerns here. So having that specialized training, talk about how this interacts with HIPAA, right? There's information that can be shared, but making sure that folks are comfortable is really key. We also are big proponents of having IRPO advocates to help guide folks through the process. It can be really overwhelming, right? If you're concerned about someone and access to their firearms, it can be really overwhelming to go to the courthouse and figure out what forms to file and use the right language and then testify before a judge. I think we can all appreciate how intimidating and overwhelming and scary that process can be. So having an advocate to help guide them it's really helpful. And then developing protocols to make sure that those orders are served appropriately and that law enforcement have all of the information they need to serve the orders. And then last set of recommendations we have are just ensuring transparency and accountability. So we are big fans of having data. Like we've all said, IRPO is still a relatively new tool. It was developed after the Sandy Hook shootings, when researchers were looking at what can we do to take firearms away from folks that are a known risk to themselves or others. So this is a newer concept. We're always looking for data so that we can better understand and better implement and utilize this tool. We know that it can save lives, right? But we want to have that data to make sure that we're all learning from one another. And then things like that are happening here, creating a process for regular review, bringing together key system actors to talk. And then we'd love to see annual reports published on what's going on, how is it operating, looking introspectively at what's being done and potential areas for improvement, because even in jurisdictions that I would give an A to if I had a report card, there are always areas for implementation. So the next slide is just a QR code. If anyone wants to scan to get a copy of this report, you can use the QR code. We can also email around the link. I think it might have already been emailed around, so you all have that. And then on the last slide, we just have all of our email addresses here to be a resource and happy to coordinate, have conversations, do whatever we can to support the great work being done by our friends here on the ground.
Thank you so much. Any questions for the team?
Hi, I'm Tracy Velasquez. I'm with the Council for Court Excellence. We're the civic organizations on the work group. It feels like a lot of what you're talking about is around preventing suicide. And I'm wondering if you could talk about differences you've seen in implementation and questions that have arisen as compared with up here, because you're saying this was implemented after Sandy Hook to prevent mass shootings, but it feels like the conversations and the processes might have to be very different if someone is suspected of being at risk of committing mass violence against others.
Yes, you mean in terms of mass violence versus.
Right, I'm just thinking about
suicide
like
violence?
if I have a loved one and I'm afraid they're thinking about hurting themselves or killing themselves, that's a whole different process than I have a loved one who has talked about killing 5 people, and it seems like that's a very different thing. And I'm wondering if you talk about like maybe like how are they being used? Is it mostly for suicide prevention? And are there differences in implementation strategies?
So I don't think we really delineated different strategies in the report for those different needs. And like Lisa said,
Yeah.
that 6-state study showed that about 10% of IRPOs were being used in response to mass violence threats. So I think, I'm sure my colleagues have more to add here, but I think that when it's being used in response to mass violence, I think then we're seeing more ERPOs being used concurrently with criminal cases as well. I think then you're more likely to see some of that SWAT coming in, a higher, a more coordinated response. I see Sarah maybe going like, maybe not. I think it really depends, and it goes back to that individualized safety plan. I think a lot of homicides are suicide homicides together, right? And so what is the threat and what is that individual threatening to do? And how close are they in time maybe to committing that violence? And thinking individualized about what you need to do in those circumstances.
So you pick up on a really good point, which is that we, and by we I mean kind of the general public, tends to talk about these kinds of laws, red flag laws, right? In the context of mass shootings. That's when they come up. But in fact, the actual day-to-day utility of these laws is probably more meaningful in the context of suicide prevention. There are probably many more circumstances where you have a concerned family member who just wants to remove that firearm, and kind of can't figure out how to do it without some kind of compulsory order, right? And so that disconnect, I think, does create challenges for public education efforts, which we didn't even really talk about here. But in really wanting to make sure that when we're doing our public messaging, we are making it very clear that this is a tool. And in fact, every town's public education messaging program around ERPO is called One Thing You Can Do. And it's very suicide prevention focused because we're really kind of into that. So I think it behooves all of us who do this work to keep that in mind, that to not kind of get led down the mass shooting path, because that's when the public tends to be interested in these things. The other thing is, and the part of what I was talking about when it comes to making sure that civilians have really strong and equal access to this intervention is for the suicide prevention context, right? I think that if you have a family member who's really concerned about a risk of mass violence, that's a situation where they're probably better off going to law enforcement, right? But if you have a situation of a person who's at risk of self-harm, that's a scenario where it is very counterintuitive to say, well, I'm going to go to the police because I'm concerned about my kid and being at risk of self-harm. And that's really where you want to make sure that there are a lot of informational opportunities and kind of supports available for those family member petitioners in that suicide prevention context.
I will just quickly add something that actually I was going to say, but I see Lisa wrote basically my same thought, is that also it bears out in the context of gun violence itself, which is that the vast majority of gun deaths are gun suicides, whereas like as much as mass shootings sort of catch the national attention and they are tragedies that we should be working to prevent, they are about 1% of all gun deaths in the country. So even from like just a pure like the problem we're trying to solve, gun suicides is just larger in number compared to how often and how sort of statistically rare mass shootings are. And so we're seeing that bear out in the sort of ERPO data as well, where most states are, I don't think they're making an intentional use of it just for suicide, but they're seeing a larger application to prevent suicide as compared to mass shootings.
I am Mark Lovetto with the District of Columbia Behavioral Health Association. One other thing that I would add, just as another piece of context in this discussion, and some of you may know some of the research better than I do, is that the evidence about mass shootings is that mass shootings overwhelmingly are suicide events. The people who go in to perpetrate a mass shooting have the intention of being dead at the end of that event. And so if we think about suicide prevention, we're also addressing mass shootings, as long as we keep in mind that mass shootings are just a kind of suicide event.
Oh, yeah, please. My question is, talk a little bit about how this relates. I'm not saying that all the other stuff doesn't make sense at some point, but we've got a couple of little issues. Obviously, we want to be a new gun ownership, legal gun ownership system. So what does that do with this? I've got a couple of questions. I know people apply for guns ownership licenses with the police department. That I understand that usually there. I mean, does the police department have you walk in their office right there that everybody knows they're available to apply this license in that office? Is this ERO information readily available for folks who are doing that kind of thing. I guess the second part of my question would be, what are we doing? We also have a city that has a lot of illegal gun ownership issues. So my question is, how does this relate to this?
That's our entire thing.
Yeah.
Great segue.
Yeah.
And I think right before we get to Sarah, and Tara will perfectly answer, I hope that question.
Yeah.
We'll go ways to it. I believe Mr. Parker on Zoom, did you have a question?
Yes, I was. Thank you very much. I saw that Clayton Rosenberg was also there, who is representing the Alliance of Concerned Men. But the question I would ask, we speak about suicide. How about from the perspective of when community gang leaders want to turn in their guns on a volunteer basis to other community-based organizations, persons? I find your procedures to be very interesting as to how it can be done pertaining to suicide situations. But I think from a prevention perspective, from a public safety aspect, when we have gang leaders that want to turn in their guns to other community-based organizations, persons who they have established good relationships with, what is the procedure for that? Or will this be a part of this conversation? And the reason why I ask is because maybe about 3 years ago, 3 to 4 years ago, a number of the kids I call them kids that was involved in different activities on 7th and O by the Kennedy Playground, they offered to turn in their guns for opportunities, jobs and things of that nature there. And we took the idea to the city. At that point in time, there was nothing in place to be able to facilitate this particular conversation. So that's my question.
And I think that's a great question. I think it's exactly kind of what we're hoping to discuss kind of at the end of this is where can we kind of expand ERPO? How can we utilize ERPO in a way that's more unique to DC, that kind of addresses the weird ways that DC operates as opposed to Connecticut or New York or Maryland. So I think it's a great question. I think the best thing to do, unless you all have a great right now, I think we'll discuss and then go ahead or we will let OAG and DCBLB do their DC specific presentation, and then we will discuss these exact questions that Mr. Parker and everyone else raised. Let me switch up here.
Hello, everybody. Now, what we're gonna present is where the rubber meets the road. It's not necessarily as pretty, but extreme risk protection orders in DC. And it was good, we just had these questions and some of these discussions, because I think we can try to incorporate some of these questions. Just the questions people ask here are some of the major things that we're constantly grappling with. And I think with the help of everybody, we can better address. I'm Sarah Connell with the DC Attorney General's Office, Domestic Violence and Special Victims at the ONG, and a lot of my work has been in domestic violence, stalking, etc. And then I've been doing ERPOs just in the time that they've been in DC.
And my name is Tara Burnine. I'm a lawyer at the DC Volunteer Lawyers Project. I work on ERPOs where appropriate. Most of my time is spent serving survivors of domestic violence who are experiencing gun violence. So I do ERPOs, CPOs, sort of wherever legal tools and survivors don't paper. But a lot of that has been sort of figuring out where ERPOs might fit into that toolbox for survivors of domestic violence on top of other tools as well. So Sarah and I get to work together pretty frequently. It is confusing that our names are so similar. But yeah. Next slide. So sort of going into the ERPO statute. So as it's been discussed, ERPOs are still so new for us compared to some places. They've only been around since 2018. We're getting a lot more use now, But we have code sections specifically for the ERPO itself, sort of like lies out, what does a petition look like, et cetera. That's all in the statute. One difficult thing in DC so far, that there's no case law on ERPOs. So you're sort of looking at the statute and then you're sort of saying, this is what I think, but there's nothing to cite to as a lawyer. That can be a little tricky. I went to law school in California doing restraining orders. There's so much case law there. And in DC, there's less on CPOs, but there's some. And on ERPOs, there's really none. So it's a lot more flexible and it's sort of like, well, the judges have been doing this, or our judge has been doing this. So if you hear us sort of make references to sort of like how it's been, there is no case law to guide us. So we're sort of guided by the statute and what's really been going on lately. Okay, we're gonna talk about more numbers now.
How many ERPOs get filed? So I would just tell the people at Everytown, we have all this information you're looking for because we take it from the court. If you want detailed information about ERPOs, you can go to the courthouse, you can sit down, you can get the files, they're publicly accessible and get all the information. That's what interns are for, but I know it's very time, but we keep track of them as they're filed. So 2019, we just had just a few, we're just starting out, as you can see, 2020, 21, and granted, this was during the pandemic too, so everything was just sort of stopped and not really going at the pace that it would normally go. But we had a lot of individuals and very few, the first one ever was MPD. We've had a few MPDs, but what happened in 2022 with the next slide, two important things happened. One is that there was MPD training that was done. It was part of the, whatever it is, the annual training that LMPD had to do, something on, that was a section on ERPOs. And the other thing is that Tara came on the scene. So you can see the huge difference here. 17 in 2022, last year we had 36. This year we've only had 12. We had like 5 in the first week or something. We were really panicked, but you can sort of see what the trends are here. And they're definitely in DC, we have a lot of individuals filing. And I think that a lot of that does have to do with Tara because of the domestic violence nexus. But just to give an example, some of the other individual filings that I've had over the years are maybe a grandmother who's filing against, say, their adult grandson who lives with her, and he has mental health issues, and she's really concerned about getting his legal gun taken away. Sometimes there's situations where they're siblings who live together who are filing against each other. But you can see there have been a number of mental health providers that sort of, it comes and goes, but we've had 2. And that might be people for DBH, and it might be individual healthcare providers too who file. But we're on a good trajectory at this point, and so hopefully 2024 keeps going up.
And I'm turning to how our actual statute works. So several groups of people can petition in DC. So there's sort of 3 buckets of it. So the first is sort of people who are related to the respondent. So blood, adoption, guardianship, marriage, domestic partnership, child in common, and cohabitating. Our statute used to say maintaining a romantic dating or sexual relationship. It was very recently changed to match our civil protection order statute. So now it's is, was, or if some of the response was, or seeking to be in a romantic dating or sexual relationship. So it just sort of is more in line with, I think, my client's experiences, for example, that you might have just broken up with someone, but they're still posing a risk to you, especially with the way domestic violence works. Just because the relationship ends does not mean the domestic violence does. So that's one change. And the other group is any sworn member of a law enforcement agency operating in DC. It used to just be Metropolitan Police Department members, but you can imagine that in a jurisdiction with Capitol Police, Metro Police, all sorts of law enforcement operating, that caused definitely some headaches for Sarah. We went, yes, NPD. So we'll get to some examples, but so now any law enforcement agency operating in DC can file. And then last group is a mental health professional. This is very broad. It is not just like a treating psychiatrist. It's like an emergency room doctor, like a lot of people you might not think qualify under a mental health professional. So those are sort of the 3 buckets. It's relation, law enforcement or mental health professional. And again, our statute was just changed. So if you see a version of the statute that, like, you might see a version of the statute floating around that might not be current, so just look out for that. Turning to some examples, so I'll talk about 2 examples that I did, and then Sarah will talk about 2 examples she was involved in. So one example is a petitioner filed a civil protection order and an ERPO after the father of her child threatened her and began stalking her. She knew he had multiple guns. She saw them 5 days before filing. She had photo evidence of the firearms. He also was formally convicted of felony unlawful gun possession as well. So there was a lot of reasons why these guns were unregistered, but he threatened her, began stalking her. She filed both. Another case, a petitioner filed an extreme risk protection order after her husband threatened to kill her. The petitioner knew that he had a legally registered gun, was not turned over in the civil protection order process. So in this case, I think the temporary protection order, which does order relinquishment of firearms, went into effect in January or February. And around July, August, there was a new threat. We knew the gun hadn't been turned over, so we sort of turned to an ERPO as like, okay, the CPO process did not get this gun out of this person's hands. Like, let's look at the next step. We filed an ERPO there as well.
So 2 more examples. This third here is MPD filed on behalf of Capitol Police. This is before the statute was changed, which was last week. Thanks to you. And so basically there was a Capitol Police officer who called us and said that they had a staffer who was being stalked by somebody she actually had no relationship with at all. He was just obsessed with her. Like, she came home and he was in her house, and that kind of thing. And she couldn't file because the way the statute was. Capitol Police officer couldn't file because of the way the statute was. We got somebody from MPD, from Violent Crime Impact Team, and I want to talk about they're now RPU, I guess the Robbery Prevention Unit, but I want to talk about how they've been really, really important in all that we've done. But that person sort of stood in as a petitioner, and we filed to get those taken away. You know what, there have been so many cases since then, so I can't even remember the details, but I'm pretty sure he had guns, he was threatening her, maybe himself as well. The fourth one here, I'm just gonna sort of lump a bunch of things in together. This MPD filed after a respondent who lives in Virginia came to DC with a firearm after committing multiple threats to violence. This actually, I've had 3 cases like this fairly recently. The funny thing is that people are always like, oh, you should do more cases like Virginia does. And then we have Virginia calling us saying, can you file an ERPO against this guy? Because we won't get one. So I guess they have a much higher, it's much harder. And these are even people in Fairfax County. So I had 3 cases where one of them was somebody who showed up in DC. Everybody likes going to the National Cathedral, and this is all public information, with guns. I don't know why. Somebody showing up at the National Cathedral with a gun illegally, having made multiple threats to different people in the past. Another case fairly recently, somebody was on the Woodrow Wilson Bridge, pointing a gun at people, and he lived in Virginia, had his guns in Virginia. And then there was another case where there was somebody else who was threatening various public officials. And we've basically been able to, because there's some legal nexus to DC, because you're threatening people in DC and bringing these guns into DC and you're not supposed to. We've been able to file orders against these people, and actually a lot of cooperation from people in Virginia and people here in DC, specifically the Office of Intelligence. They've been really good at getting these things served there. And so we have more and more Virginia respondents at this point. And I think we'll probably see more and more now that the statute has sort of broadened. ERPO process. Here's the ERPO. So somebody files a petition for an ERPO. So this can be done online. And we now have more and more police officers filing online. And it's definitely something that's fairly user-friendly in my experience. And then we we get a lot of officers who are gonna be filing online, or people can go down to the courthouse and they file a petition. Usually, and the court's really good about this, on that day that you file a petition, usually you can have the opportunity to get an ex parte or an emergency hearing. This is all remote, by the way, so it's going to be remote. So on that day, I'll tell the officers, you know, we're gonna get called in the courtroom at some point and basically talk about why we need this temporary order. At that point, the temporary order and all the paperwork will go out for service. Now, up until last week, it was only MPD who could serve. So that most of that information, most of the service packets would go to the People in the Violent Crime Impact Team, which changes its title every like 3 months, but now it's the Robbery Prevention Unit. And so they will receive a packet where they need to go serve, and I'll talk a little bit about that more in detail. And now it's gotten broader, so other law enforcement can serve, because that was really a problem. We have so many different law enforcement agencies. We have situations where we're trying to get guns from people down in Virginia and nobody's able to, we can't serve, you know, MPD can't send people down to Virginia. It's not a good use of resources. And then serve, hopefully it all works out, and then everybody gets to court, whether it's remote or in person, and on that day, there'll be a trial. It could be a consent. The judges do allow, even though it's not in the statute, a consent extreme risk protection order where somebody can agree to the order and not admit that they did any of those things. And it seems there's some people who will do that. There's definitely a lot of people who will fight tooth and nail, definitely fight tooth and nail, and to try to keep their guns. So I've had some trials that went on for days. And then I've had some where it was a trial that it was very sort of quick. But that's generally what the process is. Role of law enforcement is the next slide. Now, law enforcement officers can petition for an OPO. Generally what happens is if they do, a lot of times they'll contact me because they'll get information from somebody that they need to contact me before they file or right after they file. My goal with mental health professionals and with law enforcement, and if they're representing individuals, if it's a case Tara's not involved in, my goal is to make this as easy as possible and to waste as little time of your time as possible. And I tell law enforcement this, I tell these doctors and psychiatrists, they don't have time to be sitting in court all day, and I realize that. And the more time it takes, the less likely they are going to deal with it. And so that's what I say, look, when I get a petition from a law enforcement agent, the law enforcement officer, they contact me, I'll go in, I'll look at the person, I'll look at the CCN, I take all the material from that and try to rebuild a case without them. Because I'm OAG, I have access to all the body cam and a lot of things that are really, really helpful. So the law enforcement, they can petition, and we've had a lot of great officers, detectives, sergeants who over the years have petitioned, and then what happens, they sort of become these like unofficial sort of experts in it, and then everybody else calls them for it. And then again, law enforcement must serve the documents unless served in open court or judicial authorization for someone over 18 to serve. This is also new. It wasn't really specific about people being able to be served in open court in the way that essentially a lot of process can be served in open court. And judicial authorization for somebody over 18 to serve, I think we sort of envision that as a situation where somebody is maybe in some kind of psychiatric facility, and you could get somebody there to hand them the paperwork without having to have an entire team of police come in and disrupt everything. So that has broadened, and we're hoping that will be helpful. But what we really think in judicial authorization, it will be a judge really looking at the situation, realizing, okay, this is going to be safe for somebody to serve. It's something where somebody just doesn't have ready access to firearms.
I don't think that's gonna happen very frequently.
Exactly.
I think the reason, we had a case, I think in 2022, where I had a petitioner who wanted to file a RIPO, but the respondent was incarcerated for something completely unrelated in Virginia, and we had to dismiss the case because there was no way to get an MPD officer into a Virginia state prison. Like, it was impossible. So like, this person cannot be subject to an ERPO because of the service rules. But like, and here I think we have a law enforcement serve, but I think there's situations like that where like it would be safe, we think, for someone who's detained, maybe we know they don't have access to that gun. Someone just needs to get it instead of having to dismiss cases where it's like service became like impossible, so.
I have a quick question. Purple, it only applies to adults or does it apply to juveniles as well?
That's a question that we've gotten, and we haven't had a situation where somebody was trying to file against a juvenile. I think what we've thought of is that you might file against the guardian on behalf of the juvenile, which is something that used to happen in civil protection order cases. But I think that's something we really want to look at the best way. Obviously, by default, the juveniles, it's illegal for them to have it anyways, but that, you know, that doesn't solve all the problems anyways, obviously.
I have a question. I wanted to see the turnaround time. Getting a file in this order.
Oh, yeah, I'm sorry, I should have said that.
What's the average?
Yeah, I should have said that. So what it's supposed to be is you file the petition, you have this temporary hearing on that day, and it can only be, it has to be within 14 days that you have that final hearing. That date can get continued, certainly if both parties agree and they agree to extend the temporary order, or it can be a trial that lasts forever. Like I had one, I swear, it must have been like 3 or 4 months, because we had to file so many briefs in it too. So that's another example. Or it could be that, you know, we come one time and then somebody says, okay, I'd like to get an attorney, the respondent would like to get an attorney, or I have subpoenaed some records and I'm waiting for the records and that kind of thing. So sometimes it's within 2 weeks, but somebody is seen within 2 weeks. That always happens. I don't know what the average would be. I'd have to look at that.
And like thinking of the cases we have open right now, I would say like if there's a CPO, it can sort of,
Oh, yeah.
slow things down. CPOs tend to go on a little bit.
Yes.
So like I think we have a case that got filed. It's a CPO, but I think it got filed on January 2nd. And I think we've gotten it continued. It's not over our objection, it's been continued multiple times. And I think we're finally going to trial on April 1st for it. And I think that will be like, we are going to trial on both of those things that date. And if not, like, I don't know what I'm gonna. So like that, that is long though. Like the 3 months, like we are frustrated with that process. So I would say like a month and a half is maybe like standard if I'm just speculating, but they can go on, if people are consenting, they can go on for a lot longer.
And if there's a related criminal case, so I've had cases where there's a related felony case and the defense attorney, of course, wants to trail the felony case. And so that's situations where it can be months and months, you know, because the felony case may sort of really go on for quite some time. I've had some situations like that too.
Can I have a quick follow-up on what's the time that they have to serve the initial, like they go take the guns away between, so someone files an ERPO either, and then you said there's a hearing like that same day, and then what's the period of time that that someone goes and serves the temporary order and takes the guns?
Okay, so that's actually gonna be my next little section here. When an MPD serves an ERPO, they need to. So it gets sent very quickly. So the court is actually reorganized with this. They have different OAG listserv. Rita Blandino, director of the Domestic Violence Division, she's online here too. But they have a process by which they send it out to certain people at NPD to make sure that it gets served. And the people who handle those definitely take this seriously and do it as quickly as possible. That can be a day, it could be 6 days. It really depends on sometimes what else those people have going on. If there's like a huge demonstration or something in DC, then everybody's pulled to do something else. So that certainly can impact things, but it really depends what's going on. But I would say within that first week, they definitely try to do it. And what we tend to do is when we have a case, if we're involved in it, and we are involved in most of these cases, we tend to make contact with the people who usually serve and sort of let them know, okay, this is what's going on. this is the contact information for this family member or that kind of thing. So we really sort of try to work with them on every case. But it very often can be really quickly. Now, I will say, there's a lot of times when, and then I'll just get back to that, sorry, but a lot of times when officers will respond, I've had a number of these cases, officers will respond to somebody who is experiencing some kind of mental health crisis, and they have legal guns in their house. And they are saying, and I've had this 3 times where they're saying, there's a bunch of people who are running into my apartment before the police get there and they're taking over. Unfortunately, oftentimes this has been situations where it's been veterans with PTSD, and they sort of believe they're in a combat situation. Police get called to the situation, and then oftentimes those people might be taken in for to CPAP or something like that to have an evaluation. What the police do at that time is they do what's called a they take them for safekeeping. Yeah, they'll take the guns for safekeeping. That's what you'll see in the report, even though they're legal guns and we don't yet have an order. And then the next business day, they will file. So a lot of times when people in that kind of crisis, the guns might have already been taken for safekeeping. So there was some talk about the way that these orders need to be served. And I will say, because I've watched a lot of body cam of the police officers serving these units, serving these orders, and I will say it's pretty amazing. They definitely keep it at the lowest key possible. There's one sergeant in particular, Adam Johnson, who's in the robbery prevention unit, and he's really been like our contact for everything. And he's been working on this for 5 years with us. And when they knock on the door, they keep it really low key, extremely respectful. And when it's been legal guns, I will say they always get the people to trim it over. They're just saying, look, this is just a civil case, and it's pretty amazing the work that they do and that he does in particular. Now they have another sergeant who's working with him who's also really good. So I will say that when somebody has illegal guns, right, and this goes into a whole search warrant thing that Tara's going to talk about. When somebody has illegal guns, so somebody goes to the house and it's a situation where with one of Tara's cases where somebody has a CPO and the victim survivor is saying, look, I think that this person has a gun and I saw it 3 months ago or something like that. So the officers can go to the house and they can say, look, we're serving this with you, to you, do you have any guns? Now, if they say no, and there's no probable cause to believe that it actually is a gun there, then there's really nothing that they can do at that point. If there isn't probable cause, and she'll talk about that. So very often people who have illegal guns are going to say no. And I know that there's sort of this amnesty provision that you can, hand them over and you won't get in trouble. But I think there's a lot of skepticism, and it makes complete sense because it's, we promise you won't get in trouble. I mean, I think that's not something that people feel very comfortable with. And it's something that's a real issue, and I think we all need to talk about. But I will say that the way these officers do it, and when other officers start to serve in the district, I really need to get a lot of those people from the robbery prevention unit to do training, but they have a lot of other stuff to do too. So I realize that. Role of OAG, this is really boring. This is just what I do. I have to just file these precedents in every case. And oftentimes I'll jump into the cases that Tara has. She's doing all the work and it looks like I'm taking over the case, but she pretty much does everything. I'll look up some evidence for her and get some certified convictions. But I have to do these 3 things here. And one is just do a record, somebody do an NCIC search, and then I contact the registration people at MPD and they just tell me whether this person has legal guns. And then I have to do a search of the respondent's mental health records. And I want to just say something about this really quickly. The way we determine a reasonable search of mental health records at this point is just whatever's available. There are HIPAA protections, but like just what's available. So if it's a domestic violence situation and Tara's representing the person, I asked Tara, can you ask, has this person sought mental health treatment? Or if there's somebody who, another collateral contact, or I might look at past, I'll look in police records to see if they've been taken into CPEP or something like that. Once I have a name of a facility, whether it's PIW or DBH place or a private facility, I can file a motion with the court requesting that we get those mental health records. I will say this is a huge thing, and it makes me uncomfortable because I think for anybody here who's ever been to seek mental health treatment, if you knew that like some random lawyer, OAG, was gonna get every single bit of your file, that's really disconcerting. So I'm really careful about this. If I do get the information, it's because we really, really need it. If I'm gonna use it, we make sure we file under seal, and if it's a public hearing, that we're not sort of putting these documents out for everybody to see, because obviously it's totally counterproductive, because it's chilling for people to have this situation where your mental health records, I mean, I would never go back to a therapist after something like that. So this is something that we try to be really careful about, because it can create more problems.
So turning to search warrants, so if you read our ERPO statute, you'll see that warrants can be issued as part of an extreme risk protection order. They can be done when a final ERPO is issued, they can be done at the temporary ERPO stage, or they can be done on renewal. I think in practice though, warrants are not happening. So I think Sarah and I would love to talk more about that, because in practice, like in theory, they can be issued at all stages, but in practice, the judges in DC are applying probable cause, which we almost never have for an ERPO. So the issue really is like the timing, that by the time a case comes to one of us, it's been filed, it's been served, like it's too old for there to be probable cause, or the person who saw the firearm is gonna say, well, yeah, you just searched him with something saying you can't have a gun, and sure they moved it. And it's like, that really is not probable cause. So in theory, warrants, in practice, pretty much never, due to sort of this probable cause standard that is not in the statute, but is being applied. Okay. Turning to actually issuing the final ERPO. So the overarching question to issue a final ERPO is if it's established by preponderance of evidence, so 51%-ish, that the respondent poses a significant danger of causing bodily injury to self or others by having possession or control of, purchasing or receiving any firearm or ammunition. The reason I think this is really critical is I think that is a relatively high standard. I don't think it's a low bar in practice. I think there has to be something really concrete, like what is the reason for thinking this person is posing a danger? But B, there's no requirement that the petitioner has seen the gun, or even if we know the respondent has a gun, right? In practice, if you are making threats to shoot someone, even if no one knows you have a gun, like that I think is enough for an ERPO, because you're making those specific threats. And even if you don't have a gun, it sounds like you should not be allowed to purchase a gun, right? That the acquisition of a gun could be dangerous. So there's no requirement that that person has a gun, although I think in most of our cases, we do pretty much know that there is a gun. But again, we don't have to like prove that there's a firearm, you have to link it to them. Then final ERPOs can be done after a hearing, so you could do a full trial, or like Sarah talked about, people can just agree to them. It really depends. If you're familiar with the civil protection order process, we have attorney negotiators through the court that negotiate all civil protection orders that come through, but they cannot negotiate ERPOs. So you sort of go before the judge and the judge negotiates. It's very odd. There's very few situations where the judge is like negotiating an order like that, but ERPOs get negotiated by the judges themselves. And just a note for like who is hearing these cases in DC. We have the domestic violence division at the court. It handles all civil protection orders, anti-stalking orders, which are like civil protection orders where there's no relationship and the relationship is just the stalking. And it handles ERPOs as well. So those judges are the ones handling it. We have 2 judges on the bench at a time. And they sort of see all these cases. They tend to handle the temporary ones. Some judge in the domestic violence division will handle both the temporary order and the final order. But in addition to that overarching question of like danger to self or others, there are 8 specific factors that we look at. So like when I think of it as like giving a closing argument. And the way I frame it to a judge is sort of, there is this overarching question, but in addressing that, we're gonna look at 8 factors. Not all 8 have to be met, but this is sort of like what the statute wants you to think about in answering that broad question. So the first is any history or pattern of violence directed towards themselves or others. So I interpret this broadly. I think any history of violence. So say you have people who have been in a relationship for 10 years, but there's history or threats of violence going back 10 years. I think that's relevant in an URBO determination. 2, I would say, is the factor that we almost always see in cases, which is a recent threat of violence or act of violence directed towards themselves or others. So, you know, recent physical violence, recent threats of violence, etc. 3 is the acquisition of firearms, ammunition, or other dangerous weapons within 1 year. And this sort of looks at like, is someone stockpiling a firearm? I think that's sort of what it's aimed at. But say in a case, we have a case where we know that the respondent, the threats, the violence occurred in December, but they just got a new machine style gun in August. That's very relevant, right? And then the last one I'll talk about is the unlawful or reckless use, display, or brandishing of a firearm. We see a lot of brandishing, I would say, in both of our cases. That looks different. You know, you see guns being used to enact violence themselves without shooting, like the gun as a tool of violence. And then unlawful or reckless use, it's like things like, yeah, this person keeps the gun on the counter, or we had a case like it was kept in a lunchbox in a car. And it's like, we don't really need to know whether that's a legal gun, like that is unlawful or reckless use. You should not keep it in a lunchbox in a car. That surely it goes under here. So those are sort of the first 4.
And then the next 4, respondents' criminal history, that's something, it's not required that people have a criminal history, but sometimes they will have things that I think are very significant. Violation of court order that speaks for itself. Number 7 is the evidence of a respondent experiencing a mental health crisis. And I will say that the way our judges really look at this is they don't need to have an expert in there to present a diagnosis, but if it's just sort of indicia of a mental health crisis, for example, somebody calling and saying, you know, I'm going to shoot myself, or you know, I'm going to shoot everybody in my apartment building, those kinds of statements. Very often the mental health crisis really needs to be sort of connected to guns somehow. Like you all were saying, when it's somebody who is, you know, diagnosed manic bipolar or schizophrenic, like that alone is just not going to get you there, but it's an obsession or real interest in using guns. Respondents' use of a controlled substance as well. We don't see this as much, to be honest, people with like drug or alcohol. I mean, sometimes it's an issue, but it seems like it doesn't come up as very often for us. Special considerations, and this is sort of where we go to all the things that we need to work on.
Yeah.
Lack of clarity on search warrants against, we talked about on what the standard is and when we can do that, and because there are certain standards that in the statute that allows a petitioner to request a search warrant, and what is the standard there as compared to when it's an officer trying to get a search warrant from the US Attorney's Office, etc. Now, this is the big one, the illegal guns. One issue is, I mean, people like to say, well, you know, as I said before, you give up your illegal gun and, you know, you're not going to get in trouble. Well, people can trace it, or people can say, you know, just kidding, you know, that kind of thing. I mean, you just really never know. And so one issue is, we want to find a way to allow people to file against somebody who has an illegal gun without feeling like you're inviting the entire system into your home. Because people like to say, well, these are civil cases, they're not criminal. But It's a civil order with criminal penalties if you violate it. You go to serve a civil order and, maybe, hey, can I search this? And you see a gun and then you find out it's linked to something else. I mean, I think that there's no sort of confidence that, if you file against somebody with an illegal gun, that it's not going to create a whole host of problems for everybody, and particularly when it's in your family. So I think that's something that we really need to figure out, because it has to be law enforcement who takes the gun. I know that a gentleman was saying something about, having gang members handing things over to organizations that they trust. And I think the issue is that guns generally have to be turned over to law enforcement agencies. And so I think that's a huge issue. But I will say about illegal guns that people are like, well, why are you filing an ERPO when it's illegal anyways? And we found that when there's an ERPO file and somebody has an illegal gun, it really brings attention to the fact that there is a gun there. It gets the serving unit out there looking for the gun. Sometimes people get rid of their guns, it's not in their possession anymore, but they might give it to somebody else, which for a domestic violence victim might be a little bit less dangerous. So it really has been important, and it's sort of an extra layer of protection in that if somebody, has a felony or they have some protection or they're not supposed to have a gun, this is just an extra sort of law that they could be charged with if they violate it. But that is something that I think we really want help in. How do we do this in a way, keeping it in the civil realm to get illegal guns, particularly from family members?
And I will say anecdotally, I think we see, I would say the majority of my cases especially are illegally held firearms. But anecdotally, I think we are starting to see more in the last year and a half since I've been with UPDLP. We've seen more and more legally held firearms, which I think there's sort of this two myths in DC, which is one, there's only illegal guns and you can't get a legal gun, and it's well, no, that's not true. Or it's there's it's sort of both are wrong. There are illegal guns now, but there's also a lot of illegal guns. So we are sort of seeing both.
And I always say, they're oh, people out of DC always are that's illegal to have guns in DC. And I was you would not believe the people who have legal guns in DC.
Yeah.
I mean, everybody. I mean, if you go up to the firearms registration branch, the concealed carry line, it's 2 miles long. I mean, people have guns in DC.
So we're seeing more, but I would say still the far majority of our cases are illegally held guns. Looking towards ERPO and CPO overlap. So like I said, I do a lot of civil protection orders, pretty much all of them involve a firearm. Not all of them become ERPOs though, and there is some overlap. So for a civil protection order, you are ordered to relinquish your firearm and you're not allowed to possess one. I think sort of the biggest issue is that the CPO has no teeth in enforcing that. It's sort of read to you at the hearing, at the end of the hearing, the judge is gonna say, okay, you need to give up your guns, call this number, and you can't have them. And people basically leave. So there's not a lot of follow through on that. And there's no way for the survivor to verify that has actually occurred. So sometimes we'll file an ERPO on top of a CPO to sort of bring attention to it, act as a second layer of enforcement. Make sure that the people serving the order are gonna say you need to turn over your firearms, etc. But there are some caveats, right? Some survivors might not think that, looking at the 2 points down, I'll just jump to it. So some survivors feel that an ERPO may trigger the respondent in a way that a CPO won't, right? So the ERPO itself, all this focus on the gun might actually be more dangerous to them than just the CPO. So that's one consideration. Some clients might want the ERPO but not the CPO. I think there is sort of this idea are ERPOs going to replace CPOs? No, I don't think anyone who does them thinks this will happen. I think in the majority of my cases, you will still need a CPO to deal with things like a stay away, child custody, but it can sort of be a tool on top of it. And as a note, we tend to do the trials simultaneously. So if there's an ERPO and a related CPO, we'll do both in one proceeding. Lack of awareness, I think, is slowly getting better. We're seeing more ERPOs filed on their own, that Sarah and I weren't hey, have you thought about filing an ERPO? I had a case recently where the MPG officer told the client to go file for a protective order in Maryland, but an ERPO in DC, and I was that's still better than not. Like, we'll fix that, but like, that's not a bad start. So we're seeing more people file on their own as well. But in terms of awareness, I think there is still a lack of awareness with like people in the community who like where IRPOs may be helpful, sort of what they do, and MPD officers as well. And then staleness, there is an issue. The question has been raised by some of our judges about when an IRPO is quote unquote stale, like is the threat too old, right? Did you have to know and file immediately? We say no. But I think there is this issue of like, if you wait 6 months after the threat to file an IRPO, judges might raise questions. I think statutorily, you're safe. There's no requirement for a final IRPO that it happen immediately. You might not get that emergency IRPO. There might not be a basis for that, but you can still qualify. So that's one issue. And then sort of just like further statutory changes needed. I think Sarah and I have been working the statute, but the statute is still relatively new, and still might need some fixes. So that's sort of it. And then last question is just how they can actually be filed. They can be filed online through the court. For intimate partner cases, I can help people file. You can call our clinic line or just email me. And then for all non-intimate partner cases, you can just call Sarah directly. And we're also happy to like answer questions. I often get referrals for consults from partner organizations that are like, hey, I have this client who there's a gun involved, can you talk to them? And maybe it's an IRPO, maybe it's not, maybe we're going to use a different tool. And sometimes I'll talk to the client for an IRPO consult and it's like, oh no, you need a child custody case, but I can also help with that. Like that's cool. So sort of like figuring out what is the best tool. So we do a lot of consults, both of us, to sort of figure out when an IRPO fits, when it doesn't. Just questions, I think.
So the previous presentation said 90% were suicide related. It sounds like maybe 1% of your suicide related. No, I mean, it seems like these are all, I haven't heard any of the cases that you had that seemed like they were related to.
Looking at our numbers, we get like 1 or 2 files a year by a mental health provider, but I think that is a big awareness question too.
And I know DC has the lowest rate of suicide in the country, so it's not surprising, but it just feels like a very different utilization of these than elsewhere in the country.
Yeah, I feel like we do have suicidal, I've had some straight suicidal ones recently where it either was a mental health practitioner or just a family member. But usually it's paired with something else. It's usually like you're talking about mass shootings being suicide, but family shootings, whether it's domestic violence, like, partner or whatever, it's you're shooting, you want to kill yourself and you want to kill some other people. Or you want to go have suicide by cop and kill a bunch of police at the same time. We have somebody who kept begging for that every time the police responded. So, but you're right, it's not in the same way. But certainly police are definitely filing, MPD are filing. They'll take somebody to CPEP and then they will contact us also.
Let me just chime in on that. So Donna Dalton with the DC Coalition Against Domestic Violence. And I think that as we saw in the beginning years of IRPO, there were just a lot of low numbers. And even in total, we're not talking about a huge volume. And I think ultimately, to Tara's point, the CPO doesn't have a lot of teeth for firearm revocation. And the domestic violence attorneys in DC were like, this is a tool to help with that. I think that if we, in thinking about sort of the next steps around how do we broaden this out, like partnering with Mark and the Behavioral Health Association and other, like getting the mental health clinicians out, it could be more of a suicide related piece, but it's also like, who's doing the work or recognizing the way in which we utilize it.
I also would note that I think in a lot of my cases where there's domestic violence, there's also a threat of self-harm on top of a threat directed at her. Right. Like that is, so it might not get put in the bucket of a suicide prevention IRPO, but like there is that component of it and we see those overlap so often. And in a case where we're filing IRPO, like I would say we see that relatively frequently.
And just to let you all know, the Department of Behavioral Health, we have a mental health section at OAG, and they represent Department of Behavioral Health. There are 2 attorneys there who, when somebody, a clinician who is with DDH, they have concern and want to file an IRPO, they will be represented by them. And they sort of specifically represent DDH. sometimes those are suicides, but very often those are more sort of homicide type of calls, not necessarily mass homicide calls, but two questions here, so whichever you guys who wants to go first.
Are you? So it sounds, I'm not hearing Urpo's use in the context of community violence, like sort of the everyday violence you're seeing in the streets, and have you all seen applications of that? It sounds like the research doesn't show that. Sounds like the experience doesn't show it. So should we manage our expectations like this is really mostly a DV, perhaps suicide thing? Let's not think about it for community violence.
Well, I think it would be good to move to that place, but I think that, and I remember having a meeting who left, I remember us talking about it, because I've worked with him for a long time, talking about it several years ago, moving to that place. But the issue is the fact that it's a law enforcement driven thing, served by law enforcement, you know, and I think it's getting to the point where people feel comfortable that that's not just gonna start something for this particular person. I've definitely talked to people, parents who are calling about their kids' access to guns, family members, and I'll talk to them and we'll discuss it, but they just are like, no, this sounds like it just could go very wrong. So I think it would be great if we could get to that point. And I know I've reached out to different people around the country, and I think somebody in Chicago, and I never even followed up, is handling that kind of thing. And I think we need to look at places that are more like DC to figure out how to do that.
I was gonna just say, like, around the country, I think that we're seeing folks like dipping their toe in it and figuring out how can it work, but we're not seeing like robust models that are gonna, like, years of data showing it.
And I'm just looking at, I took some notes, so it seems like urban is more reactive, right? It's basically you know, intervening based on identified risk from, you know, individuals that say, hey, I think this person. So how do you combat that coming from a community-based standpoint? And what are like some personal or professional development things in there to counter, okay, if someone just having a mental breakdown all of a sudden, and it's a stress gets to everybody, they have a mental breakdown, and they do say something or of that nature, but then you automatically put them, you know, on this list and then, you know, get them involved in a silver, you know, lawsuit. How do you counter that? What are measures in place to, you know, help? Just, it's not a one-off, like, okay, just because someone had a moment, that moment don't put them in, you know, devastation where they can't now, you know, do anything else. So how do we look at that?
I mean, I think that is a huge issue, and I think when judges are deciding whether or not they're gonna issue, they do look at that. But I think we also consider that when people are contacting us. I mean, I will say the cases that we've had where it's a mental health issue and there's concern of suicide, homicide, it's very rare just like a one-time thing. Usually there's been multiple statements over a long period of time. But I definitely see what you're saying, because it does, you know, you could say, oh, it's a civil order, and you know, if you get a background check, it won't show up, but you know, anybody can go to the courthouse and get your stuff. So I think that that's definitely an issue. And a civil order has criminal penalties, and so there's that concern. But it's definitely not something that's for that one-off type of situation. It's usually, if it's mental health, there's a lot of statements. And if it's just one thing somebody said, I don't think the judges even get it.
Yeah.
But
And how does the trauma, you know, because trauma is a lot, right? And sometimes that trauma and mental health are obviously is hand in hand. But if, you know, coming from some of the neighborhoods that like my organization service, like we see it every day. However, we know some individuals, I just talking because it's just they don't know, you know, if you don't know better, that's what you know, that's the community. However, we know they don't need to be in this standpoint, but they basically exemplify some of the things that will say, hey, they need to, you know, report them down and they need to go and get all of these things done to them, put them on the list. But technically speaking, we know them as a community base, and I guess that goes in, how does that, you know, strategic partnership look with, you know, this, and then also community-based organizations that's on the ground that can get more of the details than somebody just going down and found something online or doing anything like that. Where is the strategy and, you know, combining the efforts where, you know, you have really community-based talking with these people every day, seeing it and can help, you know, even possibly refer some people that needs to be on it. However, you know, where's that and how do we, you know, look at that from partnership amongst each other?
I think a lot of it is we have small enough numbers, but a lot of it's sort of a case by case, and I've had people call me and say, what do you think about this, whatever, but it's the case that ERPOs are not gonna be for every situation. If you have somebody, a kid who's you're working with, and they say, oh, you know, I wanna shoot this person, whatever. You know, that's not gonna happen, it's nothing, and it's not worth that, but I think it's being able to talk to people who do these to figure out when it's a situation. And the good thing is, I mean, you can talk to us without giving us names, so we can just talk it through. But I think there are gonna be times when there probably are community members who really are concerned, want to be able to have access to this process because, you know, I always think of somebody with a child or an adult child or something like that where they have that concern, but I think that's something this group can really help with.
Yeah, I'm just thinking about, we talk about urban violence, is this the right mechanism, or is there another mechanism that we can utilize? But it seems like right now, it seems like there's a lot of unknown. And we have to be very careful in the way that we execute the work in these communities, because we have strong relationships. And integrity is most important. However, I do think the point that Mr. Parker made, if there's a way, if someone wanted to turn a firearm with amnesty, and it's not going to be traced to things of that nature, then I can see that. But this is very delicate steps that we have to consider when we talk about urban violence and work that we do.
Exactly.
And I think one thing from my cases that always sort of stands out is like, hey, they are very reactive, right? Like you said, like you can really only get a photo once a lot has happened. I would say like in my domestic violence cases, like this is never, the thing that originated the ERPO is never the first instance of violence. Like I have never filed a case like that. I don't think a case like that would get granted based on sort of how high a bar it is. But I think like the issue that my clients constantly run into is like, they're not gonna turn over an illegally held firearm, whether it's ERPO, whether it's a CPO, like it's not gonna happen. So I think without sort of like an option to turn it over that people trust, like, you know, the data on domestic violence and post-traumatic stress disorder with firearms is pretty convincing that like, it doesn't matter how the gun is surrendered, but the gun being surrendered really helps survivors feel safer, not just be safer, but feel safer and like recover and like feel like they can heal from the trauma they've undergone. So yeah, I think that's like a great point that I think like we would definitely love to talk more about because it sort of is like a gap in the system. What we can see is actually like, how do you get people to turn them over and feel comfortable doing so, knowing that they won't get in trouble? The law can say what it says, but like in practice, that's not happening right now.
Just to kind of follow up on that, so in terms of
You can't see them.
yeah, the question. Were there any cases that you saw where you said this fear of retaliation? Have there been cases of retaliation?
For my clients, not directly. I think there is a fear of retaliation. Like, I think that there is sort of like a catch-22 of like, would a lot of my clients love to have the gun taken and not be in the possession of someone who's threatening them with it? Yes. But like, is there a risk? It's sort of like that survivor will generally make the calculus then. And like, as a survivor attorney, like it's not my job to say what's what. Like, it's really up to them and like they have the agency to decide whether or not to file an ERPO. And they'll sort of decide, is it gonna be safer? Is it not gonna be safer? But I don't think we've thank God, we haven't seen any instance where there was an ERPO filed and something happened immediately after. And again, like hopefully it's gonna be the survivor's decision whether or not to file, and they'll make the calculus of whether or not ERPO is gonna make things safer or less safe.
No questions.
I'm just curious, with like the relation to civil commitment, like orders and ERPOs, is there like, ERPO that can help from a civil commitment order? Cause I know the vice versa is responsible.
Right. Once you're civilly committed, you're not supposed to.
All right.
gun ever. Yeah, I mean, well, that's a Department of Behavioral Health, I'm sorry, the mental health section of OAG. They handle a lot of those and then we'll handle IRFOs at the same time. So I do believe that there are times that people will be civilly committed and also somebody will get an IRFO, even though they're supposed to sort of being civilly committed is supposed to sort of do, excuse me, is supposed to do the exact same thing. But there are a lot of people who might have mental health issues where, and IRFOs are sort of appropriate because there's a lot of talk of guns and gun violence, whatever, but they may not be somebody who will be civilly committed. Obviously, to be civilly committed is fairly high standard. I don't know if that answers your question.
No, it's a.
Okay.
That's my question, is to follow back on, I think all of us are communities. But I think this warrants a conversation, all of us, because this is the first time some of us even understand this. I think there are a lot of things that we probably need to talk this out at different levels. So I think as we're moving this forward, the conversation probably needs to be had directly with us. Because there are a lot of questions, a lot of concerns, a lot of comments that we're gonna have as we move this forward. I know this is a police side of this, but there's also a community side of this that's very, very important. I think this one is probably a bigger conversation that we need to have. I know there are things that other cities have done. This is Washington, so I think we gotta have a conversation with folks in Washington about what we feel is probably the best practice for us here.
And I think that the thing that we've talked about before is this even the best mechanism, or does it need to be something that's a variation of this? And like, what would that be? So.
And I think IRFOs are still like such a narrow tool, like 36 was like a huge number of cases for us, but like they're really such a narrow tool. The criteria are so specific, the criteria you have to meet to like even fail is so specific. That in terms of like broad applicability, like you really do have to meet these like very niche statutory factors and like kind of go from there. So we are sort of pinned in by the statute.
And to that point, I think this is worth highlighting. I don't think anybody thinks that IRFO is now the new #1 gun violence prevention approach, like at all. So I think that like, you know, for those of us who spend a lot of time thinking about these laws, it's really how do we use this tool to address these pieces of gun violence? And is there a way for this tool to, like, are we making sure that this tool that is designed to do this one narrow thing is doing that one thing well for every community in which it can do it well? So it should just be one very small piece of a much larger, much more comprehensive and diverse approach to all of the different.
And I think when you compare, you know, this here to Washington State or just some different states, I mean, it's literally just a completely different landscape. I mean, a completely different landscape. So yeah, I mean, I think it's really hard to compare and contrast, but this is not the solution. It's especially when you're talking about DC, it's a small sliver of, it sort of looks at a small sliver of the issues.
And I just have one last question when it comes to understanding the approach of, like, as Mr. Tyrone Parker mentioned, that initiative for Guns for Opportunity. It's like what incentives do we give individuals that want to turn their gun? And is there an MC piece behind that?
Right.
Like, are they going to be, you know, some guns they turn in, we want the guns off the street, and we know some guns may be connected to certain crimes or however. So how do we look at that when we're talking about, you know, collecting these guns, but then also giving individuals who's asking for help, who really want to put their guns down, but can't because of the environment or any other circumstances? How do we look at that and understand, like, you know, this is just one piece, but where's that incentive? You know, you have to, nowadays, you got to give people something and give up something. It's a quick broke, and it works. But what are we giving them other than, you know, this is just, you know, putting them on that list and it's almost pushing them down, criminalizing, however you put it. But what do we give these individuals to get the guns off these streets?
I don't think the IRFOs are not designed to do that. I mean, I think that's something that sounds like it would be something legislative where people can give up guns to non-law enforcement. I don't know. I mean, I don't know. I don't work in that. But I definitely don't think that that's something within, you'd be trying to fit that within the structure. It's something different, but I think it's important for you all to realize what this can and can't do. And I'm really honest with people. If you go and get an ERPO against your grandchild, like this is what it could be inviting into your home, the scrutiny and that kind of thing. And sure, it's, you know, amnesty, but you just really never know, so.
Isn't OAG working on a gun diversion program too? I believe that there's a pilot, you know, so maybe that's something that grows out of it.
That's a juvenile,
On the juvenile side, just to go back to the question about, you know, how to help juveniles. But I mean, I echo, you know, everything that's been said in terms of the importance of the community. I'm Dr. Amy Mack, Office of Gun Violence Prevention, and you know, the community piece is huge. And I think when we make a differentiation between survivors or victim survivors and perpetrators on the community level. I mean, you know, someone could be a victim or a survivor and then also be a perpetrator. I mean, it's very different than what we see in other kinds of violence, and that's something to think about too, you know, in terms of what we can create. I'm hopeful to Dell's point too, like, so these are the mechanisms we have in place, and as lawyers, you know, you follow what the statute says, but hopefully this is an opportunity for us to come together with the police, with the community. You know, the Office of Gun Violence Prevention is, you know, we're supposed to be helping with the coordinating and the collaborating, and we are so different that what, you know, it needs to be, I think, driven from the community, and the answers are in the community. And how do we help? But yeah, I mean, we can't overpromise when you're on the ERPO, and suicide is, you know, I'm on the Child Fatality Review Board. We definitely have cases of young people who have shot themselves, you know, by having access to firearms. But when we're looking at the bigger issue here, where the majority of our homicides by guns are within the community with illegal firearms, what do we do? And if you're finding people aren't giving them up, I mean, part of it is, I'm not sure, do people even know about it? You know, to me, the red flag laws for legal firearms only. I mean, Spencer and I have talked, and it's like, no, so there are things we can do. So my hope, my point and my hope is that I think it's great we come together. I think we need to think about, I don't know how council, what's the expectation here? You know, you bring us together. If you're just, you know, you want to talk about suicide, I think, you know, we can, and I'm a clinical psychologist by training. There was TerraSoft. I don't know what ever happened to TerraSoft, the duty to warn, duty to protect. Like, these things have been around decades. I swear I start to date myself, how old I am. But, you know, so when we say this is new, it's 10 years old. That's, to me, that's a long time. So how do we get to a better place than where we are right now for the district? You know, less so about the other states. What do we need to do?
I think that's exactly right. And representing my boss and the council here, I think it would have been great if we fixed this whole thing today. I guess we're not gonna figure out every problem today. But I mean, the questions that persist right now, there's this procedural kind of efficiencies that Tara and Sarah raised. But beyond that, I think the question that you said exactly, Del, you know, what would a use of ERPO look like that could be a helpful tool to those in the violence interruption community? That's the big question because of how DC's play markets. As Sarah said, it is designed where the focus is the gun. And I know, you know, when I speak to folks in the VI space, that's their focus too. Your focus is on harm reduction. And so if this can be used in that way, if there's a world in which that sounds like there's an ERPO out there that you would feel comfortable kind of, you know, encouraging your members to use, I want to know what that looks like. Or if not, then, you know, my phone, email is always open to talk about other options like you were raising as well. But that's my big question right now. It's because, you know, we want to raise awareness. Part of this, the big step of this meeting was to bring more awareness, as was mentioned. A lot of folks just aren't aware of this, and in some cases, this might be a good tool. In cases of, and Sarah, one question I had is, when it comes to amnesty, we have amnesty of basically the illegal possession of the gun. So it is a kind of unique way where if you know that, you know, maybe if the grandmother knows her grandson just got this gun, has nothing else in the only crime this possibly could be tied to is the possession of the gun, different kind of scenario than not knowing, and that's where that risk comes in, right? And the whole goal of the grandmother, right, she doesn't wanna get her grandson in trouble, doesn't wanna get him arrested, she just doesn't wanna have a gun. And so, I don't know how much,
The
yeah,
grandson may have gotten the gun from a
right,
friend.
exactly,
You know, he's going
this is exactly what I mean, no, I know,
Yeah.
right, that's what I mean. And so this is my question, if there, we have this amnesty, we have, it relates to the voluntary surrender law that we also have, right? You could, the grandmother could call her grandson and say, go turn your gun in, right, and you will get the same kind of provision. Equally unlikely, right, in a lot of scenarios, so I'm curious if there are views on what that could be, what an expansion that looks like, or if it's, or if we're just talking in a different category.
I'm just wondering, maybe this is, it seems like it is 3 o'clock. I know I have another
Yes, it
thing.
is. Thank you.
Is there a plan for the next meeting where we can maybe break this up into chunks and really take a hard look at different chunks of this?
I think that's a great plan. This is the first one, and the goal is, let's make sure we all know what an ERPO is. Which I think, check, I think we're all good on that one, okay? And so.
Can and more importantly.
Right, exactly, yes, we have not solved all gun violence in the district today, but I think breaking it into subject matter kind of groups, specifically talking about community violence, mental health, domestic violence is a logical next step.
I'm sorry, I think it's also helpful, there were a number of things highlighted today, like this judges are doing this and they don't do this on anything else, and I thought I had seen, I don't know if Josie, our senior court or senior judge, like, isn't there, we need representation from, who am I thinking? Isn't it, from the court, I guess, yeah.
Got the Rita.
Oh, okay, so.
Good
afternoon.
All right, hi, so, yes, so I mean, and that's also, it's great, we have, we didn't go around in terms of all that, but so thinking about, can we look at different systems perhaps, right? Like, so what do the courts need in terms of OAG? And when you're prosecuting, you've highlighted things, but then there are those of us who can also respond and say, well, okay, could it be adapted or adjusted or thought through in some of the other ways? I'm afraid if we come through subject matter expert side, I don't know.
My second question is, how should this group be most functional? I know, Spencer, you mentioned that there's this is one of the recommendations, and that's good. I'm curious how this type of work group works in other states and how it can be best served the purpose.
I think every jurisdiction is so different, so I think it's up to the folks in this room to decide what would be most helpful for everyone.
Maybe as we send around the slot, go ahead.
Exactly. You said, I think you provided me with the race national, like Dale, the folks from the Alliance, all of us are the violence intervention service providers. So our point of view is going to be community. How this looks, judge-wise, system-wise, we now got to go back to the people who are dealing with all 3 of the categories you can say. So we got to make sure everything that's here, we're able to act for. I think that's the reason when we talk to the mom and the grandma about this, she doesn't even understand what this means. Because first of all, she hasn't heard from anybody but people who are talking about it from a legal side. And if she's hearing it from Dale and all of us in the community, that what this actually is, that's a whole different conversation. And she's listening to it from a whole different lens. So I think that the community side of it really has to be a piece of this somewhere. That's just my.
There's a whole strategic communication piece, right? Like, I mean, we all can remember this is your brain on drugs, right? Whether that was effective or not, but there is a messaging, there is, so what are we trying to achieve? But I think Sarah's point, if the ERPA wasn't developed for this, then is there something else that we can be doing on behalf of our residents here that we're trying to help and support? What would that look like?
And that's why I'm at, because if it's not the mechanism, let's not stretch it and try to force it to be the mechanism. There's other things that they think best, and that saves us all a bunch of time.
Yeah, I totally agree. Yeah,
Totally. It seems like, sorry, Erin from Giffords, it seems like it may be worthwhile to look at the process and see where are the opportunities to bring in the community organizations. Like talking about the grandma, if she is worried about her son or her grandson getting in trouble, maybe the community violence intervention is a better resource for them in that moment, or at whatever process, like if an ERPO is issued, obviously that person is in a state of mind where they want to harm someone else, and there needs to be a connection, because you don't want that person not just twisting in the wind
without resources. So like, where are these kind of intervention points in the process where the community organizations can be more involved?
And I think to identify, are there barriers, perceived barriers, like, oh, I don't want to use this because to your point, like now am I on a list and now I'm gonna have all these consequences for the rest of my life? Are there provisions in the ERPO where someone can respond to a crisis in the moment and it doesn't have these repercussions for years and years? And how do we, is it already built into the law or is that something we need to?
And to not have such duplication of services. Our victim services, I think we have shown, somebody mentioned that earlier, duplication. We see a lot of that in some of the work CJCC and OGDP are doing too. We see that.
Well, I don't wanna keep everyone, so thank you all. I don't wanna, we've been here for a while in this tiny room that does not seat this many people. So I appreciate you all coming. I think, I appreciate everyone online for joining. I don't think this should be the last meeting of the ERPO working group, and maybe we'll be focusing on things besides just ERPO. And sort of particular circumstances, or how to better use ERPO. So, thank you all for being here, and I will be in touch with next steps, and as like I said, my email, phone, office, always open for any thoughts, ideas.
Thank you.
Thank you all.
Thanks.